Employment is a relationship between two parties, usually based on a contract where work is paid for, where one is the employer and the other is the employee. An employee contributes labor and expertise to an endeavor of an employer and is usually hired to perform specific duties which are packaged into a job. An employee is a person who is hired to provide services to a company on a regular basis in exchange for compensation and who does not provide these services as part of an independent business. Employer-worker relationship. Employer and managerial control within an organization rests at many levels and has important implications for staff and productivity alike, with control forming the fundamental link between desired outcomes and actual processes. Employers must balance interests such as decreasing wage constraints with a maximization of labor productivity in order to achieve a profitable and productive employment relationship. Finding employees or employment. The main ways for employers to find workers and for people to find employers are via jobs listings in newspapers and online, also called job boards. Employers and job seekers also often find each other via professional recruitment consultants which receive a commission from the employer to find, screen and select suitable candidates. However, a study has shown that such consultants may not be reliable when they fail to use established principles in selecting employees. A more traditional approach is with a help wanted sign in the establishment. Evaluating different employees can be quite laborious, but setting up different techniques to analyze their skill to measure their talents within the field can be best through assessments. Employer and potential employee commonly take the additional step of getting to know each other through the process of job interview. Training and development. Training and development refers to the employer's effort to equip a newly hired employee with necessary skills to perform at the job, and to help the employee grow within the organization. An appropriate level of training and development helps to improve employees' job satisfaction. Employee benefits. Employee benefits are various non-wage compensation provided to an employee in addition to their wages or salaries. The benefits can include housing, group insurance, disability income protection, retirement benefits, daycare, tuition reimbursement, sick leave, vacation, social security, profit sharing, funding of education and other specialized benefits. Employee benefits improves the relationship between employee and employer and lowers staff turnover. Organizational justice. Organizational justice is an employee's perception and judgment of employer's treatment in the context of fairness or justice. The resulting actions to influence the employee-employer relationship is also a part of organizational justice. Workforce organizing. Employees can organize into trade or labor unions, which represent the workforce, to collectively bargain with the management of organizations about working and contractual conditions and services. Ending employment. Usually, either an employee or employer may end the relationship at any time. This is referred to as at-will employment. The contract between the two parties specifies the responsibilities of each when ending the relationship and may include requirements such as notice periods, severance pay, and security measures. Wage labor. Wage labor is the socio-economic relationship between a worker and an employer, where the worker sells their labor under a formal or informal employment contract. These transactions usually occur in a labor market where wages are market determined. In exchange for the wages paid, the work product generally becomes the undifferentiated property of the employer, except for special cases such as the vesting of intellectual property patents in the United States, where patent rights are usually vested in the original personal inventor. A wage laborer is a person whose primary means of income is from the selling of his or her labor in this way. In modern mixed economies such as that of the OECD countries, it is currently the dominant form of work arrangement. Although most work occurs following this structure, the wage work arrangements of CEOs, professional employees, and professional contract workers are sometimes conflated with class assignments, so that wage labor is considered to apply only to unskilled, semi-skilled or manual labor. Wage slavery. Wage labor, as institutionalized under today's market economic systems, has been criticized, especially by both mainstream socialists and anarcho-syndicalists, using the pejorative term wage slavery. Socialists draw parallels between the trade of labor as a commodity and slavery. Cicero is also known to have suggested such parallels. The American philosopher John Dewey posited that until industrial feudalism is replaced by industrial democracy, politics will be the shadow cast on society by big business. Thomas Ferguson has postulated in his investment theory of party competition that the undemocratic nature of economic institutions under capitalism causes elections to become occasions when blocks of investors coalesce and compete to control the state. Employment contract. Australian employment has been governed by the Fair Work Act since 2009. Bangladesh Association of International Recruiting Agencies is an association of national level with its international reputation of cooperation and welfare of the migrant workforce, as well as its approximately 1,200 members agencies in collaboration with and support from the Government of Bangladesh. Canada. In the Canadian province of Ontario, formal complaints can be brought to the Ministry of Labour. In the province of Quebec, grievances can be filed with the Commission des normes du travail. Pakistan has contract labour, minimum wage and provident funds acts. Contract labor in Pakistan must be paid minimum wage and certain facilities are to be provided to labor. However, the acts are not yet fully implemented. India has contract labor, minimum wage, provident funds act and various other acts to comply with. Contract labor in India must be paid minimum wage and certain facilities are to be provided to labor. However, there is still a large amount of work that remains to be done to fully implement the act. Philippines. In the Philippines, private employment is regulated under the Labor Code of the Philippines by the Department of Labor and Employment. United Kingdom. In the United Kingdom, employment contracts are categorized by the government into the following types. Fixed-term contract. Lasts for a certain length of time, are set in advance, and when a specific task is completed, ends when a specific event takes place. Full-time or part-time contract. Has no defined length of time, can be terminated by either party, is to accomplish a specific task, specified number of hours. Agency staff. Freelancers, consultants, contractors. 0-hour contracts. United States. In the United States, the standard employment relationship is considered to be at will, meaning that the employer and employee are both free to terminate the employment at any time and for any cause, or for no cause at all. However, if a termination of employment by the employer is deemed unjust by the employee, there can be legal recourse to challenge such a termination. Unjust termination may include termination due to discrimination because of an individual's race, national origin, sex or gender, pregnancy, age, physical or mental disability, religion, or military status. Additional protections apply in some states. For instance, in California, unjust termination reasons include marital status, ancestry, sexual orientation or medical condition. Despite whatever agreement an employer makes with an employee for the employee's wages, an employee is entitled to certain minimum wages set by the federal government. The states may set their own minimum wage that is higher than the federal government's to ensure a higher standard of living or living wage for those who are employed. Under the Equal Pay Act of 1963, an employer may not give different wages based on sex alone. Employees are often contrasted with independent contractors, especially when there is dispute as to the worker's entitlement to have matching taxes paid, workers' compensation, and unemployment insurance benefits. However, in September 2009, the court case of Brown v. J. Cas. Inc., ruled that independent contractors are regarded as employees for the purpose of discrimination laws if they work for the employer on a regular basis, and said employer directs the time, place, and manner of employment. In non-union work environments in the United States, unjust termination complaints can be brought to the United States Department of Labor, U.S. Federal income tax withholding for purposes of U.S. federal income tax withholding. 26 U.S.C. 3401 provides a definition for the term employee, specific to Chapter 24 of the Internal Revenue Code. For purposes of this chapter, the term employee includes an officer, employee, or elected official of the United States, a state, or any political subdivision thereof, or the District of Columbia, or any agency or instrumentality of any one or more of the foregoing. The term employee also includes an officer of a corporation. This definition does not exclude all those who are commonly known as employees. Similarly, Latham's instruction, which indicated that under 26 U.S.C. 3401 the category of employee does not include privately employed wage earners, is a preposterous reading of the statute. It is obvious that within the context of both statutes the word include is a term of enlargement, not of limitation, and the reference to certain entities or categories is not intended to exclude all others. Labor unions are legally recognized as representatives of workers in many industries in the United States. Their activity today centers on collective bargaining over wages, benefits, and working conditions for their membership, and on representing their members in disputes with management over violations of contract provisions. Larger unions also typically engage in lobbying activities and electioneering at the state and federal level. Most unions in America are aligned with one of two larger umbrella organizations: the AFL-CIO, created in 1955, and the Change to Win Federation, which split from the AFL-CIO in 2005. Both advocate policies and legislation on behalf of workers in the United States and Canada, and take an active role in politics. The AFL-CIO is especially concerned with global trade issues. Sweden. According to Swedish law, there are three types of employment. Test employment, where the employer hires a person for a test period of 6 months maximum. The employment can be ended at any time without giving any reason. This type of employment can be offered only once per employer in employee combination. Usually a time-limited or normal employment is offered after a test employment. Time-limited employment. The employer hires a person for a specified time. Usually they are extended for a new period. Total maximum 2 years per employer and employee combination, then it automatically counts as a normal employment. Normal employment, which has no time limit. It can still be ended for two reasons. Personal reason, immediate end of employment only for strong reasons such as crime, or lack of work tasks. Cancellation of employment, usually because of bad income for the company. There is a cancellation period of 1 to 6 months, and rules for how to select employees. Basically, those with shortest employment time shall be cancelled first. There are no laws about minimum salary in Sweden. Instead, there are agreements between employer organizations and trade unions about minimum salaries, and other employment conditions. There is a type of employment contract which is common but not regulated in law, and that is hour employment, which can be normal employment. But the work time is unregulated and decided per immediate need basis. The employee is expected to be answering the phone and come to work when needed, e.g., when someone is ill and absent from work. They will receive salary only for actual work time and can in reality be fired for no reason by not being called anymore. This type of contract is common in the public sector. Age-related issues. Younger age workers. Young workers are at higher risk for occupational injury and face certain occupational hazards at a higher rate. This is generally due to their employment in high-risk industries. For example, in the United States, young people are injured at work at twice the rate of their older counterparts. These workers are also at higher risk for motor vehicle accidents at work, due to less work experience, a lower use of seatbelts, and higher rates of distracted driving. To mitigate this risk, those under the age of 17 are restricted from certain types of driving, including transporting people and goods under certain circumstances. High-risk industries for young workers include agriculture, restaurants, waste management, and mining. In the United States, those under the age of 18 are restricted from certain jobs that are deemed dangerous under the Fair Labor Standards Act. Youth employment programs are most effective when they include both theoretical classroom training and hands-on training with work placements. Older age workers, those older than the statutory defined retirement age, may continue to work, either out of enjoyment or necessity. However, depending on the nature of the job, older workers may need to transition into less physical forms of work to avoid injury. Working past retirement age also has positive effects, because it gives a sense of purpose and allows people to maintain social networks and activity levels. Working poor. Employment is no guarantee of escaping poverty. The International Labour Organization estimates that as many as 40% of workers are poor, not earning enough to keep their families above the $2 a day poverty line. For instance, in India, most of the chronically poor are wage earners in formal employment, because their jobs are insecure and low-paid and offer no chance to accumulate wealth to avoid risks. According to the UNRISD, increasing labor productivity appears to have a negative impact on job creation. In the 1960s, a 1% increase in output per worker was associated with a reduction in employment growth of 0.07%. By the first decade of this century, the same productivity increase implies reduced employment growth by 0.54%. Both increased employment opportunities and increased labor productivity are needed to tackle poverty. Increases in employment without increases in productivity leads to a rise in the number of working poor, which is why some experts are now promoting the creation of quality, and not quantity, in labor market policies. This approach does highlight how higher productivity has helped reduce poverty in East Asia, but the negative impact is beginning to show. In Vietnam, for example, employment growth has slowed while productivity growth has continued. Furthermore, productivity increases do not always lead to increased wages, as can be seen in the United States, where the gap between productivity and wages has been rising since the 1980s. Researchers at the Overseas Development Institute argue that there are differences across economic sectors in creating employment that reduces poverty. 24 instances of growth were examined, in which 18 reduced poverty. This study showed that other sectors were just as important in reducing unemployment as manufacturing. The services sector is most effective at translating productivity growth into employment growth. Agriculture provides a safety net for jobs and economic buffer when other sectors are struggling. Models of the employment relationship. Scholars conceptualize the employment relationship in various ways. A key assumption is the extent to which the employment relationship necessarily includes conflicts of interests between employers and employees, and the form of such conflicts. In economic theorizing, the labor market mediates all such conflicts such that employers and employees who enter into an employment relationship are assumed to find this arrangement in their own self-interest. In human resource management theorizing, employers and employees are assumed to have shared interests. Any conflicts that exist are seen as a manifestation of poor human resource management policies or interpersonal clashes such as personality conflicts, both of which can and should be managed away. From the perspective of pluralist industrial relations, the employment relationship is characterized by a plurality of stakeholders with legitimate interests, and some conflicts of interests are seen as inherent in the employment relationship. Lastly, The critical paradigm emphasizes antagonistic conflicts of interests between various groups that are part of a deeper social conflict of unequal power relations. As a result, there are four common models of employment. Mainstream economics. Employment is seen as a mutually advantageous transaction in a free market between self-interested legal and economic equals. Human resource management. Employment is a long-term partnership of employees and employers with common interests. Pluralist industrial relations. Employment is a bargain exchange between stakeholders with some common and some competing economic interests and unequal bargaining power due to imperfect labor markets. Critical industrial relations. Employment is an unequal power relation between competing groups that is embedded in and inseparable from systemic inequalities throughout the socio-politico-economic system. These models are important because they help reveal why individuals hold differing perspectives on human resource management policies, labor unions, and employment regulation. For example, human resource management policies are seen as dictated by the market in the first view, as essential mechanisms for aligning the interests of employees and employers and thereby creating profitable companies in the second view, as insufficient for looking out for workers' interests in the third view, and as manipulative managerial tools for shaping the ideology and structure of the workplace in the fourth view.